I'm Derryn Rolfe. As Victoria said, I'm a legal director in the construction engineering team at Burkitt's. I'm going to talk about the various non-regulatory issues of the Building Safety Act. I am at home having tested positive for COVID, so I'm relying on rural broadband. So consequently, somebody at the iStructy is very kindly going to move my slides on for me. So I'm afraid I'm going to sound a bit like Chris Whitty on this. So may I have the next slide, please, Joe? Thank you. So an outline, first of all, of what the Building Safety Act looks like. It's a huge piece of legislation. It has 171 provisions. Someone told me it was 220 pages, but I've actually not looked at it in hard copy. But for an act, that's very big. It's divided into 6 parts. There is no logical way of working through the act because of the way that it's drafted fundamentally. So parts 1 and 6 are general provisions. Part 1 of an act is always the sort of preamble and stated objectives, and part 6 simply gives the various relevant secretaries of state the power to do various other things. So those are what you might call the infrastructure of the act, really. Part 2 is about the building safety regulator and their duties, which Dan has already covered. Part 3 is changes to the Building Act. Part 4 is about higher risk buildings as they are now defined. And part 5, frankly, is a number of other things that have been lumped together in the way of legislation because they had no other sort of real hope. Broadly, the Act amends 3 other acts. That's how it actually works. So it amends the Building Act 1984, the Defective Premises Act 1982, which is only applicable to residential buildings, and the Health and Safety Act at Work, etc., 1976. Because that's how it is drafted as listing amendments to other existing acts, it's not actually particularly easy to read, which I suspect is one of the reasons why there's so much confusion going on. The other reason, of course, is that it was drafted in quite a hurry for an act of this size, with a lot of changes at the late stage. So it's not the best piece of legislation in terms of holding it together, but it certainly will achieve the aims it set out to do. So it amends these 3 acts. It changes the legal landscape on recovering losses from unsafe buildings. It set up some new structures for regulating building in the future, and it brings in new obligations on the management of building safety risk. May I have the next slide, please? Thank you. So what I want to look at this morning is what's in force now, because that's the most important thing. Primary legislation acts sometimes can stand on their own and act, to coin the phrase, of themselves, but most of them now require secondary legislation or regulations, as they're called, in order to bring them into force and have sufficient detail and procedures and obligations and liabilities actually laid out to make them workable in practice. The Building Safety Act definitely comes into the category of needing regulations, and so far we've got 3 new regulations come in. There's the first one, commencement number 1, the second one, commencement number 2, and the third one, there's a pattern here, commencement number 3. I'm going to go through what those have brought into force, and also I should mention that the Building Safety Leaseholder Protections England Regulations 2022, nice snappy title, has also come into force, which talks about what landlords can and can't attempt to recover from leaseholders by way of costs of remediation. And I'm also going to touch on the Fire Safety England regulations because they're coming into force very soon. Next slide, please. So if we look at the commencement, can we go back one, please? I missed one. Thank you. If we look at the commencement number 1 regulations, they were dated 19th of May of this year, but the different parts of the Act that they brought into force came into actual direct application at different times. It's just the way the government decided what was the priority or what were the easy wins to pick off. So the number 1 regulations covered putting the building safety regulator on a statutory footing, which Dan has talked about being part of the HSE, inserting the definition of higher risk building into the Building Act 1984. That was another one that came in June. A higher risk building being, in this context, over 18 metres or 7 stories, containing at least 2 residential units, dwellings, and being self-contained. So that's the definition that runs through all the new duties of building risk management going forward. The regulation introduced building liability orders. It introduced Section 48. Dan has touched on the fact that there's a new regime for what were improved inspectors, now called building approvers. And those who were the improved inspectors, as opposed to local authority inspectors, had to have insurance for what they did that was through a government scheme. This has now been changed under Section 48 so that it's now open market insurance. So that's come in before the building approver scheme in order for the insurance to actually get sort of set up and in place and available. It introduced the new right of social housing occupants to escalate complaints to the Housing Ombudsman Service. This didn't come in until October, but it was very much felt to be righting a wrong that private tenants could go to the Ombudsman, but social housing tenants couldn't. So that's now been put on a par. And there were changes to the limitation periods, which I'll talk about a bit more in a minute, under the Defective Premises and the Building Act. Although I should point out that although the changes to the limitation periods came in June, the Section 38 of the Building Act is still not actually in force, so they are a bit theoretical at the moment. Next slide, please. Thank you. The last two things that the number one act regulations brought in were introducing a new cause of action on construction products, as Dan's already mentioned, and strengthening the powers of the Architects Registration Board in respect of competence, training and approval. Not entirely sure why the architects came in for that rather than anybody else, but it was something that was felt to be necessary. Next slide, please. So, commencement regulation number 2 focused on one particular section of the Act known as building industry schemes. Now, a building industry scheme kind of sounds as though it might be sort of a membership thing, but actually it's so not going to be. The Act has been drafted very widely to allow for whatever schemes the Secretary of State may wish to bring in for whatever purpose relating to the objectives of the Act. But basically, a scheme can be established for any purpose connected with, and this is the phrase that's used throughout the Act, securing the safety of people in or about buildings in relation to risks arising from the buildings or improving the standard of buildings. That's the phrase that's common throughout all the provisions. That's what the Act is trying to achieve. And the schemes that can be brought in, basically, eligible persons who, at the moment, we don't know the extent of these eligible persons. The obvious first call will be developers and maybe contractors, but it could be, and we just don't know, it could be that it's actually engineers, architects and other professionals as well. So it is something that perhaps members of the ISTRAC team need to be just slightly aware of in case eligible persons is deemed to include the building professionals. The idea of these schemes is a sort of joint carrot and stick approach. The stick bit is much bigger, funnily enough, and the carrot is simply being allowed to be a member of the scheme. In order to be allowed to be a member of the scheme, an eligible person, basically you have to be deemed to be suitable by whoever set up the scheme and for whatever conditions it applies to. So it's a kind of approval that you may continue carrying on working in the industry fundamentally. Next slide, please. So the membership conditions are listed here. I'm not going to go run through them because they're fairly obvious, but it's to do with making the eligible people, in order to be allowed to enter the scheme, are going to have had to dealt with remedying defects, making contributions, not use construction products that they shouldn't have done, provided information on requirements. It's definitely what's the word I'm looking for? A set of conditions of what you've done in the past, rather than necessarily what you are going to do in the future, in order to be deemed to be eligible to join the scheme. And if you're not eligible to join the scheme, that's where the next section comes in. Next slide, please. Because Section 128 allows either the Secretary of State or the HSE or whoever at the moment, it will depend on the individual scheme, to be prohibited from carrying out the development of land. So that's kind of critical, really. And they do it in one of two ways. It's laid out here, but I won't go through it in detail. Either by saying that the person can't get, or if they have already been given when it comes into force, it will be null and void, planning consent in respect of any development. Or, if I may have the next slide, please, they won't be allowed to apply for or get building regulations on a development. So it's very much, if you're an eligible person and you're not allowed into the scheme, you can be prevented from actually carrying out your business, your job. It's quite a big stick. It's a massive change for the English sort of system. And it does only apply in England because Wales, through devolution, are doing it their own way, as it were. But it is going to be a very big change in how things are done. And the developers particularly are looking at the moment to wait to find out what is intended with these industry schemes and how it's going to be run, and how heavily those prohibitions are going to be applied. Next slide, please. So the amendment number 3 regulation comes into force today. So very, very new. It brings in 3 more sections of the Act. Section 4 imposes a duty on the building safety regulator to assist in a character versus stick manner people to improve safety, particularly in high-risk buildings, but also specifically for disabled people, because the Grenfell inquiry found that disabled people had a particularly left in a particularly bad position. Section 9 obliges the regulator to set up a building advisory committee, which replaces the old building regulations advisory committee, to advise him, and the regulator has been appointed to him, on matters connected with its building functions, not with its competence and training functions, but the building functions. So the regulator will be able to take soundings, take advice, take input from the industry about what is appropriate and what is not. And finally, Section 11 obliges the regulator to set up a residents advisory panel, which will be made up of residents of high-risk buildings, and that must be consulted before the regulator issues guidance to any such residents. It was felt at Grenfell that the residents hadn't been listened to, and I'm sure that was absolutely the case. And so this is set up to make sure that that's not happened again, that residents are listened to in respect of safety in these buildings. Next slide, please. So what's important? A couple of things that I want to highlight for you that have been particularly important. The first one is limitation periods. I mentioned that there were changes to the Defective Premises Act for residential and the Building Act for all buildings in respect of limitation periods. In English law, the limitation period is the length of time after a problem has arisen, generally, in which you can take legal action against the person who's responsible. For centuries, it's been somewhere around the 5 or 6 years mark. In the 1930s, it was codified so that it was around, depending on the type of action, it was 6 years in contract. If the contract had been executed as a deed, it was a maximum of 12 years. In tort, it was 6 years. Personal injury was 3 years, and various things like that. So, but this has been around for centuries and centuries and centuries. So this act is a massive change, because what it has done is it's for claims arising after the 28th of June, that's current claims, as it were, so where the defect has now arisen, the maximum limitation period has gone from 12 to 15 years. And retrospectively, in order to catch all those buildings that have turned out to have been built with materials that are inappropriate, retrospectively, it's 30 years. Now, this is going to cause a huge number of claims to come forward. In fact, it already is. The only thing I would say, and I have already mentioned, that the limitation period in respect of the Building Act 1984, because Section 8 of the Building Act isn't yet in force, there's still no real way to take action for failure to comply with building regs. So that's a bit theoretical at the moment. We were expecting Section 38 of the Building Act to be brought into force at the same time as the BSA. was given royal assent, but it wasn't. We don't know why, and there's as yet no timetable when it is coming in. So these Limitation Act period changes only apply to the Defective Premises Act at the moment, but of course they do apply to the new cause of action for defective construction products that mentioned as well. So those are also 15 years prospectively and 30 years retrospectively. The important thing about the defective construction products situation is that it includes the ability to take action for personal injury, property damage, and economic loss, which wouldn't have been possible beyond the property damage had it not been brought in. So it does give tenants and leaseholders who've suffered loss both of a personal nature and economically the opportunity to recover that loss, which I think is felt to be just. Next slide, please. So how does this affect members of the ISTructee? Well, in terms of your appointments when you're working on projects, you need to look at the limitations of liability because they are all going to be changed. So they're going to be longer. It's going to be 15 years rather than 12. There's going to be the financial risk of appointments in respect of what you will be liable to. So it's important you look at the limit of your services in terms of exactly what it is you are being appointed to do. Make sure it's as precise as possible. Don't have just provide structural drawings, do the calcs. That's not going to be good enough because that means you are going to be wide open in the future for claims. Warranties and assignments of warranties, again, that's going to be important because the limitation periods are going to go effectively to 15 years, and therefore there are going to be more assignments during that time, probably, unless you manage to get them limited. So it's important to keep an eye on the number of assignments of a warranty, because the more people it gets assigned to, the more a risk that somebody tries to come after you, even though it may not be anything to do with you. They'll go after people with the insurance, with the deepest pockets. There is a high risk there's going to be a lot more claims tried, even if not necessarily successful. In terms of your documentation on projects, you're going to need to retain the documentation for longer. So whereas previously we might keep things for 6 or maybe 12 years if it was done under a deed, you're now going to need to keep it for the full 15. If you've got stuff that's going backwards, don't chuck it, basically, because you may need it in the event that somebody, as I say, tries to put you in the firing line for a claim. So it's you're going to have to retain more documents for longer than you thought you would. Obviously, there's a cost associated with that. There is the difficulty of the ongoing changes in technology and how things are stored and whether or not you can recover them, and that's a problem we've got looking at evidence for the old claims. But of course, the use of BIM should, in theory, help this, although it's not relevant, it's not appropriate for all projects, of course. So insurance is going to be a problem, PI insurance, because the period of cover, of course, is now going to have to go up to 15 years. Whether or not the market will bear that, we don't know yet. Undoubtedly, it will increase the cost. There's never any argument about that. And it might actually cause a risk with what PI insurance is actually available. And all that this boils down to is there are going to be more claims, whether they've got foundation or not. There are going to be claims. Next slide, please. I'm nearly done. So what's coming to force next? Just a quick last one quickly, because it's coming to force next month and not a lot of people are aware of it, although it doesn't come out of the Building Safety Act, it comes out of the Fire Safety Order 2005. There is some new requirements in terms of people who are responsible for buildings, landlords, managing agents, that sort of thing, to keep information and provide it to the fire service in terms of the design of the building and materials that were used in the building and various fire kind of things like escapes and refuge areas and where the sprinklers are and that kind of thing. So it may be that people will be coming to members of the structurals in order to get information on things you may have worked on in the past, in order to include that in their set of necessary information to provide the fire service.